406. Senator Schroer, whenever you are ready.
Thank you, Mr. Chairman. For the record, Nick Schroer, Senator for the 2nd District, St. Charles County. And I've been reminded from my good friend, Senator Washington, that I have to mention her. You're already in my speech. So do I get extra points how many times I mention you? Okay. So yes, we do have the current bill 406 before us, which is certification of juveniles. There are several aspects to this that we are working on a current substitute for this, moving the age from 15 back down to 14. It's going to incorporate something from the Prosecutors Association, which would allow for their juvenile office or the prosecutor where the offender committed the crime to have standing instead of where the offender, the juvenile, resides. But with that, I would open it up to any questions. I know this is the legislation that I had on the floor just the other day discussing as a possible amendment. We pulled it back. We worked on a couple other issues. And again, my friend Senator Washington and I have been working on this since about 2018 when the Raise the Age bill passed in the House. So with that, I will close.
All right. Any questions for Senator Schroer? Seeing none, first witness in support of Senate Bill 406.
Good afternoon. My name is Sarah Johnson, and I am the head of the Missouri State Public Defender System Youth Defense and Policy. And I've been representing young people across the state for about 13 and a half years in delinquency proceedings, and I now run the Children's Defense Team. So many of you know that Missouri is a model for its rehabilitative practices. The Missouri model is a model for treating the whole child in juvenile court so that the child becomes a productive member of society. This bill continues our reputation as a leader in the juvenile justice system. Practically speaking, I'm going to just break it down a little bit for you about what a certification hearing is. A certification hearing is a hearing where the court has to decide whether a child should be sent from juvenile court to adult court. The hearing is held before a judge where there are 10 factors that are considered. The first 3 factors deal with the offense and the seriousness of the offense, and considering what happened, how the young person was involved, and whether it involved people or property. The final 7 factors deal with the child, their involvement with the juvenile system, and whether or not they can be rehabilitated. Raising the minimum age from certification from 12 to 14 or 12 to 15 supports Missouri's reputation of being a model for rehabilitation, and it recognizes that kids are different, that kids can receive effective treatment, whether it be mental health treatment, substance abuse treatment, and be released back into society and be productive members. Additionally, the portion that Senator Schroer added with regard to a probable cause hearing model is what's required in adult court. Right now, a child could be sent from juvenile court to adult court without there being a meaningful hearing to determine whether a crime was committed and whether that young person was involved. And there's no way for the attorney to be able to meaningfully challenge those facts. There are several cases in Missouri that outline that juvenile officers and legal officers do have the ability to put on witnesses with regard to the allegations, and so this is just in support of that. And if there is a probable cause determination made and the judge finds that the offense is serious, certainly the judge can send that young person into the adult system. Additionally, just want to highlight the data around certified young people. So in fiscal year 2021, only 15, 17-year-olds were certified. 10 individuals older than 18 years old were certified, 7 16-year-olds, and 3 15-year-olds. So I think this supports the data that shows that raising the age, again, from either 12 to 14 or 12 to 15, that is supported. Finally, what I'll highlight is younger children are at risk of being victims of violence in custody, as more than a fourth of youth younger than age 13 were victims of violence in custody in jail, as compared to 9% of 20-year-olds. Missouri has done a great job of addressing this by implementing the statute 211072, which requires that young people be held in detention centers and they can continue to receive educational and therapeutic services until they're 18 years old. The last piece of data that I'll just highlight for this committee is that the DYS model, the Missouri model, works as demonstrated by the recidivism rates. So the DYS data shows that after 1 year, only 89% of young people were successful. And after 3 years, 73% of young people were successful and had not recidivated. So I applaud this bill, and we are in support of it. And I welcome any questions.
Before we move into questions for the witness, we do have a quorum now, so Brad, could you please call the roll?
Senators Luetkemeyer,
Here.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. Got a quorum.
We do have quorum. I would make a motion that we go into executive session. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say nope. The ayes have it. We're in executive session. Now make a motion that we bring before the committee for consideration House Bill 301. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. Bill is before the committee. Just for the benefit of the committee, this was the bill from Representative Roberts last year that had a handful of provisions in it. The one that received the most attention was the special prosecutor provision that would allow the governor in certain cities that have a certain crime rate to be able to appoint a special prosecutor to come in and handle some of those violent criminal cases. Everyone should have received a copy of a Senate committee substitute. In short, we did not add any provisions into the bill. What we did is we kind of took out and made a few modifications based on some of the witness testimony that we had received and some of the feedback we received from members of the committee. That core provision relating to the special prosecutor is still in the bill, with a few changes, most notably one from the vice chairman that adds armed criminal action to the list of offenses that are eligible to be prosecuted. We did take out a provision with the permission of the bill's sponsor over in the House that would disallow the governor from appointing the attorney general to serve as the special prosecutor, so the governor would have that flexibility to appoint the AG. With that, be happy to take any questions or open it up for further committee remarks before I make a motion to adopt the substitute. Any discussion? Seeing none, I would make a motion that we adopt the Senate committee substitute for House Bill 301. Do you have a second? Second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say no. The ayes have it. You have adopted Senate committee substitute for House Bill 301. I would now make a motion that we vote do pass Senate committee substitute for House Bill 301. Do I have a second? Second. It's been moved and seconded. Any further discussion? Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. 4-0.
For your vote of 4-0, you have voted do pass Senate committee substitute for House Bill 301. For the benefit of the members of the committee, we are going to leave the board open until we adjourn the hearing for members who want to still vote on this and the next bill that we have. Next, I would make a motion that we bring before the committee Senate Bill 74. Do you have a second? Second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. Senate Bill 74 is before the committee. This is Senator Trent's bill relating to DWI diversion programs, and I'm going to kick it over to Senator Trent to explain the underlying bill as well as a Senate committee substitute that he distributed today.
Thank you, Chairman. So there is a committee substitute that's been distributed. We've tried to address some of the concerns of the prosecutors, and happy to keep working with them. We've also worked extensively with MoDOT, which is the agency, of course, that will oversee the deployment of the devices. Changes I would highlight, we added that no injury or death should have occurred in the course of an accident in order for someone to be eligible for this kind of program. And we also looked at the provisions related to when a person is a prior offender. Try to make sure that the current 5-year look back on prior offenders is conformed to, not making a change there, but making sure it's conformed to existing statute. So with that, if anyone has any specific questions, I'd be happy to answer those.
Any questions for Senator Trent? Senator Rehder?
I just wanted to say I'm going to vote to have this come out of committee today, but it doesn't mean I'm going to be voting for it on the floor. I still have some concerns. My concern is just that it hits the community I grew up in, the poor community, more than, you know, folks with means don't typically have this issue, and I've seen it time and time again, and so I don't want to just add one more layer of issues for folks who are already trying to get to work. And so I want to reserve my floor vote. This is a vote to get it out of committee. I do think it deserves more discussion and merit. So thank you.
Thank you. Any further discussion on Senate Bill 74? Hearing none, I'd now make a motion that we adopt the Senate Committee substitute for Senate Bill 74. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say no. You guys have it. You've adopted Senate Committee substitute for Senate Bill 74. Now make a motion that we vote do pass Senate Committee substitute for Senate Bill 74. Do you have a second? It's been moved and seconded. Any further discussion? Seeing none, Brad, please call the roll.
Senators Luetkemeyer, Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. 4-0.
For your vote of 4-0, you have voted to do pass Senate Committee substitute for Senate Bill 74. And now make a motion that we exit executive session. It's been moved and seconded. All those in favor signify by saying aye. Aye. The contrary say no. We are out of executive session. Back on Senate Bill 406. And so for the witness, one of the questions that I have is you had mentioned that I guess last year there were only 3 juveniles who were 15 years old who were certified.
Sure, so it was fiscal year 2021 is the most recent DYS data and the most recent Office of State Court Administrator data that we have.
Okay, and then assuming that we would pivot to a committee substitute that was alluded to by Senator Schroer that would take the minimum age from 12 back to 14. So do we have any statistics on, I guess, how many 12-year-olds or 13-year-olds, because those would be the only ones that were excluded, how many 12 or 13-year-olds were certified in fiscal year 21?
They were not. 15 was the youngest age group.
15 was the youngest.
That's correct.
Okay. Do we know historically, going back before 21, when was the last time we had a juvenile under the age of 15 that was certified as an adult?
I remember representing a 14-year-old senator that was certified to stand trial as an adult, but I do not, in my time, in my 14 years, remember any 12 or 13-year-olds that were certified to stand trial as an adult. I do know that there are other individuals in this room that may also have that information.
Okay. If for some reason we don't get that during the hearing, I'd like somebody to provide the committee with some statistics on that. Knowing historically how many children under the age of 14 have been certified as an adult and the nature of the crimes that they were certified for.
Happy to provide that.
Great, thank you. Are there any other questions for this witness? All right, seeing none, thank you for your testimony.
Thank you.
And please remember witness form.
You got it.
We're going to now switch over to witnesses in opposition. Do we have any witnesses in opposition today? All right, seeing none. Vice Chairman thinks this is a consent bill. I don't know if I agree with that or not. But further witnesses in support of Senate Bill 406.
Good afternoon, Mr. Chairman, members of the committee. My name is Marcia Hazelhorst, and I'm the Executive Director of Missouri Juvenile Justice Association. We are a statewide not-for-profit whose mission is promoting justice for children, youth, and families. With me today is Bill Prince. He is the Chief Juvenile Officer and Court Administrator from the 31st Judicial Circuit, which is Greene County, Missouri. Bill also serves as the policy team chair for the Missouri Juvenile Justice Association. And we're here today to testify in support of Senate Bill 406 for all the reasons that have already previously been mentioned by the earlier witness. We do support the bill for the most part overall. There is one provision in the bill that has to do with the evidentiary probable cause hearing. We did have an opportunity to speak with the sponsor prior to the hearing, as well as spoke with Senator Washington a little bit prior to coming in. So we do have some concerns about that provision, and I think Bill is going to kind of outline what some of those concerns are.
Right. I think primarily the concerns we have, or the main purpose of a certification hearing is not to determine guilt or innocence or even likelihood that the youth committed the offense. Rather, the purpose of a certification hearing is to determine suitability of services, whether those exist in the juvenile system or whether, because of the factors that Ms. Johnson talked about, the youth would be better served in the adult criminal justice system. We have some concerns about creating another hearing that would sort of look at those guilt or innocence issues, even though it would be on a probable cause basis. Number one, court resources and time. We are already dealing with incredibly crowded juvenile court dockets. We are seeing the number of certifications go up. We agree fundamentally with the data that Ms. Johnson presented about the relatively few numbers of certifications that have happened in the past, but with the advent of Raise the Age, I can just tell you anecdotally from Greene County, in the last 15 years, I think there was a total of less than 50 youth certified in all of those years. And within the last year, that number we've had 10. So we are seeing a significant increase in the number of certifications. So we are a little bit concerned about the resource availability, court time, and that sort of thing. Additionally, the same judge who would potentially be hearing a hearing on a petition, if the case is not certified, would be the same judge hearing the evidence on the probable cause hearing, which again doesn't occur in the adult system. Additionally, juvenile officers are bound by the Juvenile Officer Performance Standards of 2017, which require that we are not to file a petition or really take any action on a case unless there has been a legally sufficient referral first sent to us, and that's a referral that's been fully investigated by law enforcement, vetted by attorneys, and those initial findings of probable cause at least made by the office. Additionally, if the youth is in detention, those issues could be addressed at the detention hearing when continued detention of the youth is being considered. And before a determination to certify a youth is made or not, the prosecuting attorney should be contacted and provided with the information to determine whether or not the prosecuting attorney is going to take that case or not. They may not take the case because they don't believe that the evidence is there, or they may not take the case for other reasons. But again, a certification I cannot imagine would go forward if the prosecutor was not going to handle the case once the juvenile court dismissed jurisdiction. But other than that, we are in agreement with the bill, whether it turns out to be 14 or 15. Those of us in the juvenile system believe in the redeemability of youth, that no youth is irredeemable at the age of 12 or 13 years of age. And so we do support the bill.
Yeah, I had a similar note to myself when I was reading the bill for the first time about the separate evidentiary hearing to determine probable cause. I mean, it seemed like even if that was something that we were inclined to do, there would be no reason to do the hearing separately. I've handled some pro bono cases in the juvenile justice system, and those courtrooms can get very crowded, and there's a lot of distracting things for the kids that are going on during those hearings and their parents as well. And so I think adding an additional sort of bureaucratic layer would be something that I would be a little bit hesitant about. So thank you for those comments. Further questions for either of these witnesses? Seeing none, just if you could both remember to please fill out and leave witness form. Thank you. Greatly appreciate it. Further witnesses in support of Senate Bill 406?
Good afternoon, Chairman, members of the committee. My name is Mary Chant, and I'm the director of the Missouri Coalition for Children. For the reasons already stated, we would like to go on record in support of Senator Schroer's Senate Bill 406. We support moving the age to 15, but any improvement, any escalation from 12 to 14, we would also support.
Any questions for this witness? Seeing none, thank you for your testimony. Please remember witness form. Further witnesses in support of Senate Bill 406.
Good afternoon, Mr. Chairman, members of the committee. My name is Jeremy LaFavor here today on behalf of Empower Missouri. I want to hash over everything that everybody said, but we want to go on record in support.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 406.
Good afternoon. My name is James Robinette Jr. I'm here on behalf of the Missouri Conference of the NAACP to testify in support of the bill. I'll just read from my statement, and that'll be my testimony. We believe that it's more appropriate to treat youth under the age of 15 as juveniles in the criminal justice system in order to try to treat them and to turn them away from their bad behavior and turn them to constructive behavior in our society.
Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 406.
May I leave this here, sir?
Yes, please do. Seeing none, any witnesses for informational purposes only? Seeing none. Daryl, would you mind if I asked you a couple of questions? And I don't know, you can fill out a witness form either, maybe best for informational purposes.
Whatever you say, Senator.
Yeah, all right. So the first question I guess that I have is, at the end of the bill, we're removing rulemaking authority from the department under page 7, and I can't, and maybe I can talk offline with the bill sponsor on this, but do the prosecutors have any thoughts on that?
No, I start saying no, Your Honor. No, Senator, we do not.
Appreciate the vote of confidence. So I'm assuming the vice chairman had mentioned working with the prosecutors on a committee substitute. Is the concern that the prosecutors have the age lowering?
No, no, Senator. Our concern was, as Senator Schroer mentioned, is that and as the Mr. Prince mentioned, we just feel that prosecutors should be involved in the process.
Okay.
Should be consulted by juvenile. Now, I'll be honest with you, some of my members feel that the prosecutors ought to be more heavily involved in the initial decision, but under the current system, the change we really want, we don't have whether it's 14 or 15, we do not have an opinion on that. I will tell you, when I was Greene County prosecutor, we did certify, as I recall, Mr. Prince, in the mid-2000s, we certified, I think, 3 to 5 15-year-olds who were involved in crack distribution and robberies and violent crime, but I don't ever recall a 14. In the 28 years I was in the Greene County Prosecutor's Office, I don't ever recall us certifying anyone under 15.
Okay. Yeah, and one of the other things that's in the bill, and I can, again, have some more offline conversations about this, we're removing the drug distribution charges that are currently in the statute as a certifiable offense.
Like I said, we took no position on the bill overall, deferring to the juvenile officers. I will say some of the members do have concern. You could have young people out in the community distributing drugs.
Right.
One of the
And that's what this is. To be clear, the provisions that are bracketed out on page 2 of the bill are not possession charges. They're distribution and manufacturing of controlled substances, which I would have some concerns removing that as a certifiable offense. And I think you would probably agree as a prosecutor. I mean, most violent crimes that occur that result in a homicide or an attempted homicide usually involve a drug deal that's gone wrong.
Anecdotally, I would affirm that and tell you that in the mid-1990s, we had the Gangster Disciples move in from Chicago. The leader of that group was 17, and his co-lieutenants were 16. And they were involved in terrorizing a community in Springfield where they were housed. They were involved in shootings at each other and endangering other people. So for informational purposes, I would offer that does raise a concern, because you do see violent crime involved in distribution and not necessarily the possession. But we have seen it, and it continues today, that you see a lot of violence among young people. I think some of the people that Mr. Prince may have had to certify recently are young men in Springfield that are engaged in drug crimes and also violent crimes involving firearms.
Right. And of course, and this is true for all the crimes that are listed under Section 1 of the statute, but some of these could be repeat crimes. So in other words, you have a 14-year-old, for example, that is involved in distribution or manufacturing of a controlled substance, and this is not their first run-in with the law. And we would be taking away that as a certifiable offense if they had a crime like that multiple times.
True, and again, I would say my recollection is that recently some of the 15-year-olds that may have been certified have been involved in multiple incidents, and that's before they were even probably caught. It's become a terrible problem. Young people, not only in the larger urban areas, St. Louis and Kansas City, it's become a terrible problem even in Springfield, where we have young men under the age of 18 who believe they can do anything they want with a firearm and drug distribution and get by with it.
Yeah, and I'm standing corrected with what I just said earlier. What it would do is it would remove distribution and manufacturing crimes from the mandatory certification hearing. So the judge would still have discretion to certify. It's just there would not be a mandated hearing if we removed it from this section. So thank you for coming forward. I know I put you on the spot a little bit. I'll leave it to you how you want to fill out your witness form. Any questions, other questions for Daryl? Seeing none, thank you for your testimony. Any further witnesses for informational purposes on Senate Bill 406? Seeing none, this will conclude the hearing on Senate Bill 406. Next up, Senate Bill 129, Senator Brattin.
Good afternoon, Mr. Chairman. For the record, Senator Rick Brattin, 31st Senatorial Districts. Before you is Senate Bill 129. I did have a sub distributed. The only change in that is the change of changing it from clear and convincing to preponderance of evidence in the hearing. So that is the change in the substitute. Basically what this bill does, we've heard this bill several times here in the Senate, is establishing equal shared parenting at the onset of a dissolution of marriage and a custody for the kids in this. Back in 2000, I believe it was 16, in House Bill 1550, we passed 8 factors to weigh into to kind of help the process with custody of children. And this bill does nothing to affect that. So basically, it's just a starting point of we're going to start when the dissolving of a marriage occurs, that we're going to start at equal footing for each parent to have equal time with their children. Divorce is not anything that we want. The best thing for children is an intact family. Of course it is. But in the unfortunate circumstance where this does happen, the kids need both parents, and they need input from both parents equally. Unfortunately, for generations, my wife included, her parents were divorced, and she only got to see her dad every other weekend, and was only able to have that input from her father that she desperately needed. And I think that was the incorrect move. We kind of had, as the pendulum of these things swings, it went way too far in one direction. So what this does, it equalizes that, and it allows the court to deviate from that process, and and we'll go from there during the court proceedings. One thing I did want to point out, which it's in the actual just bill, I didn't look in the, it does encourage that the General Assembly encourage the court to enter a temporary parenting plan. To me, that's vital because these things can drag on for a very, very long time, and if we don't have this established to where kids, we're going to start this process before it completely plays out, and could be a 2-year process. It could be detrimental for relationships of kids, and I think it's just important to have something like that in there to try to speed up the process in these trial hearings. So we've got plenty of people to testify. I know that can get much deeper into the weeds, but this is a good bill, and I would entertain any questions. And thank you, Mr. Chairman, for the hearing.
Any questions for Senator Brattin? Seeing none. Can we get a show of hands how many witnesses in support we have for the bill? Okay, and then how many witnesses in opposition? Okay. What we're going to do then is first witness, just kind of among yourselves, decide who the main witness is going to be. That witness, we won't have any time limitations on how long they can testify, so I'd pick the person who's going to give the most substantive testimony, and then for subsequent witnesses, we're going to limit testimony to 2 minutes a witness.
Hello, good afternoon. My name is Jeff Miller. I am a practicing family law attorney and also a volunteer lobbyist with Americans for Equal Shared Parenting. I wanted just to pick up on what Senator Brattin mentioned with respect to entering that temporary order. This is this bill's 9th year. It's my 6th year being involved. Over the course of those years, we've actually had judges come and testify for informational purposes. One was Judge Jessica Cruz. She testified for a few years down from Christian County. And Assistant Presiding Judge Hilton testified last year. He's the Assistant Presiding Judge from St. Louis County, the biggest county in the state. And I just wanted to highlight quickly his testimony to link into what Senator Brattin said, specifically that, quote, this is from the Senate committee hearing last year where he came. Quote, I'm here basically because this bill does further the administration of justice. He testified for informational purposes. Quote, let's talk about parity. Everybody that testified here today is right on the mark. It will save money for families. And if there's a presumption where the court can basically enter an order right from the get-go of a truly shared custody plan, I would have an opportunity to observe how this family co-parents. So that's the reason for the temporary order right up front. While the court retains jurisdiction, it can make necessary changes depending on how the parents parent. Otherwise, what happens now is the judgment is made final, case is over, parties go away. If there's a problem, they've got to come back on a modification, more time, more lawyer fees, more uncertainty. So I just wanted to highlight that comment from Senator Brattin and the reasoning behind it. Given my background, I've practiced for 22 years, gosh, 12 of those in family. I would welcome any questions the committee may have with respect to the bill.
And just one question. On page 3 of the bill, this is that subdivision 8, starting on line 70. There's some changes to the language about the child's preference of which parent has custody, but there's some new language in there. I'm assuming this is to deal with situations where kids are pressured to say one parent versus the other. Is that the reason?
So, yes, but it's a little bit broader than that, because what happens is then the child is just literally a pawn used by the parents. And imagine saying, hey, little Johnny, who do you want to go live with, mom or dad? The point of this change is so we can ask instead, hey, Johnny, how would you like to go live with mom and dad? Mom and dad. So it takes, while still a component, it takes the pressure off the child when we change it from wishes to the child's input. And yes, it should be their unobstructed input. So, you know, try and meet them at a neutral location, at school, during recess, at a friend's house, free of course, coercion and manipulation. But that's the idea behind that.
Any further questions for the witness? Seeing none, thank you for your testimony. Please leave your witness form behind. Do we have any witnesses in opposition today to the bill? Okay, do we have any witnesses for informational purposes? Okay, witnesses, further witnesses in support, testimony limited to 2 minutes.
Thank you, Chairman and Committee, for having this hearing, and thank you for having it before spring break. It's very nice. Thank you, Senator Brattin, for sponsoring this bill. For the record, several witnesses were here last week, and they couldn't make it back this week, but hopefully they'll send in written testimony. My name is Linda Reitzel. I'm from Cape Girardeau, Missouri. I am a Missouri chair of National Parents Organization and have been working on this issue for 9 years. I was an original. I'm not a political operative, but when my son went through family court and had his time with his daughter significantly decreased, I knew that something had to change. Having been working on this language intensively for 9 years, I feel qualified to share with you some points that I hope will be helpful for the committee from both a legal and a cultural standpoint. Quite simply, legislation has cultural consequences, and this is no different when it pertains to the judicial legal system. What the rebuttable presumption will accomplish is for two people, even before they are married, to recognize that, unless there are serious factors, they will co-parent their children in the event of a divorce or separation. It also ensures child welfare by encouraging both parents to remain active in their children's lives. This change in law will reduce parental conflict and will also free up docket time for those cases that have a reason to go to court. This statute change provides judges with the tools they need to clearly make decisions in the best interest of children and make custody law uniform throughout the state. Rebuttable presumption of equal shared parenting has passed the House twice with overwhelming bipartisan support, and it has passed Senate committees as well. So it has legislative support, and Missouri citizens are in favor of this change. I want to urge you all to make this simple change a priority this year. Children need and want equal time with both parents. This equal time allows for great relationships with not only parents but extended family also. Children need these close relationships for a feeling of belonging, contentment, self-esteem, and well-being. Missouri policy should encourage these relationships because we have all seen what the destruction of the family in this country has brought to bear. We must do everything in our power to keep both parents actively involved with their children. This change will not financially cost anything but the cost that will be saved by having more secure and happy children.
We're going to go ahead and we've gone over the 2 minutes.
Will be immense. Oh.
I noticed you had a second page there. I was gonna let
It's
you finish,
quick,
but
okay.
what we can do though is we can, if you want to leave a copy of your full testimony behind,
It's in
we
my
can have that-
testimony.
we can have that
Okay,
distributed.
thank
to
you
the
so
committee.
much.
Any questions for the witness? See none, thank you for your testimony. Next witness in support.
Good afternoon, Chair, Senators. Excuse me. My name is Kenneth Rosa. I'm a citizen of the St. Louis County Circuit Courts, and when I went through this 7 years ago, even though I've never been convicted of any crimes or misdemeanors or ever been in any serious legal trouble, I lost access to my children except for every other weekend and occasionally, if she wanted to, a dinner visit a week. So what we've seen in the 7 years since then is that the contention of having a custodial and a non-custodial adversary against adversary is we've seen an increase of violence against parents, where we're now having nationwide shootings at drop-offs and all of this stuff because one parent feels that they own the other parent. And so it's just a contentious, adversarial, negative impact that we're having on our communities. One quick way to, for sure, drop those crime numbers that you were just talking about in the last bill is to let kids have equal access to their fathers. That's statistically proven. If you put kids back in their fathers' lives, the crime rates go down by almost 70%. So this issue also affects that bill that you guys have just passed out of the committee. And our laws have to catch up to what we have going on now. The family dynamic, since these laws were instituted in the 70s and 80s, has changed. And if we can bring, excuse me, the laws into the 2023 year and give parents equal access to their kids and kids equal access to their parents, we can lower those crime rates as well as take the adversarial effect out of it, and our communities will be better for it. So that's all I wanted to say. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 129?
Good afternoon. Hi, I'm Linda Jones. We're from Poplar Bluff, Missouri. My husband Charles and I have been working with Equal Shared Parenting for 8 of the 9 years that this bill has been similar. This bill or similar bills have been before the Senate. We're here because in 2014, the lives of 2 of our grandchildren were turned upside down with a divorce. When their mother filed for divorce, my son was kept from his children for, well, until they went to court and soon got a visitation schedule for him to see his children. In that period of time, the kids who only live like a couple football fields from us, that's where their house is, they would sneak off and come down to our house. If they would see their dad's pickup down there, they'd come down to see him. And sometimes when he wasn't there, they would slip off, come down through a wooded patch between us and their house and sneak in the back door so their mom couldn't see them as they ran across the road. They'd wait for her and run across when she wasn't looking. They'd come in and many times they'd cry because they were unhappy and wanted things to be back like they were, and that made me cry because their little hearts were broken. When they would slip off to come and see Charles and me, I dried many tears from that little 10-year-old girl and 7-year-old boy because they would just pour their hearts out to us. They have 2 aunts, 2 uncles, and 15 first and second cousins on our side of the family. They were very close to all of them. I tell them repeatedly how much we all love them, how much we will always love them, and how they'll always be a part of the family regardless of what happens or what anybody says. I did this to try to give them stability of some kind while they were going through this divorce, which was contentious, and it wasn't just their mother's fault. Their dad had a fault in it being contentious too. I think if it was to do over, it would be done differently now. But it's just so wrong for children to be put through this. this kind of trauma. Divorce hurts them enough without tearing away one parent and half of their roots. They shouldn't have to deal with this at a young age or any age, really. Family gatherings just aren't the same without all of us there. They're missed so badly when we have our family in and these two are gone. Their dad gets a holiday schedule with them, and we're very thankful for that. But that doesn't take care of birthday parties for cousins or our grandpa or I. It doesn't take care of trips with cousins. Up until just the last couple of years, Charles and I would take the kids on. The kids get an age group that was about the same and take them maybe away for a weekend or something. Or even trips, 30-minute trip up to the family farm to be outdoors and just roam the farm and maybe swim in the river for a while. Or Sunday afternoon visit to see a great-grandparent of the kids. Or even making a batch of cookies, maybe. Those are impromptu things. Those are things that you don't plan and they just kind of happen. Well, they didn't happen for these two because they weren't there with us anymore. A starting point of 50-50 custody would have solved most of these problems, especially during this time of my life. Life is short and uncertain, and I was reminded of just how much that is this past October when I received a liver transplant, just in time to save my life. I'll be forever grateful to the donor and the donor family, and I'm so humble for the receipt of this gift. But now I'm acutely aware how every day counts, every day. Putting off acting on something like this that needs to be finished is not a wise decision. These two children and their grandpa and I have missed so much time together because there's no 50-50 and the starting point, and because there was the plan, the parenting plan the judge gave was followed. In other words, there weren't exceptions. If the kids wanted to stay all night and mom had them, they didn't stay all night with us. If they wanted to stay all night and dad had them, he had 2 nights, and that's 50% of his time. We couldn't do that. So they just didn't get to stay all night. They missed the times when grandma and grandpa were their heroes. And that went on through the time when a kid gets 12, 13, 14 years old, they began to develop their own social life. And grandma and grandpa aren't the heroes so much anymore. It's the friends and the rock stars and the movie stars and the things like that. But
Ma'am, I'm gonna, just to make sure we have time for all the other witnesses.
Okay, I'll wrap
we
it up.
probably need to move on, but I do want to thank you for your testimony, and thank you. I know this is emotionally very difficult to be here to talk about some of these things, but I'm gonna.
it is. It is hard. And I thank you for the time to do it. The
Thank
only
you.
thing I would say is it's too late for me to make those cookies with my grandkids. But it's not too late for another grandma to make her cookies with her grandkids.
Thank you for your testimony. Any questions for the witness? Seeing none, thanks again for your testimony. Further witnesses in support of Senate Bill 129.
Wait a minute, I have to leave my witness form. Thank you.
Any further witnesses in support? Seeing none, I think we already covered there are no witnesses in opposition or for informational purposes. So this will conclude the hearing on Senate Bill 129. Next up, Senate Bill 446. Senator Senator Washington, whenever you're ready.
Thank you, Mr. Chair and committee. I'll get it. Senate Bill 446 is a copy of something we filed and passed out of this committee before. It simply just modifies what we pay incarcerated people who are later found innocent, what we pay them in restitution. Currently, the state only pays restitution for those found not guilty by DNA. This would allow anyone who has been incarcerated by the state who is eventually found not guilty to be also access those funds. We're not changing the amount, we're just opening the population. And with that, I'm open for any questions.
Great. Any questions for Senator Washington? Seeing none. Witnesses in support of Senate Bill 129.
Mr. Chairman and members of the committee, Darrell Moore, Executive Director for the Missouri Office of Prosecution Services and the Missouri Association of Prosecuting Attorneys. We testified for this bill last year that the senator offered, and we would support it again. As she said, in 2006, this body, the legislature, passed a bill providing for restitution to people that were found actually innocent due to DNA testing. All this bill does is add to it any person that's convicted of a felony that is found actually innocent in a proceeding would be entitled to restitution. So we strongly support the bill, as we did the bills that we testified for last week.
Thank you. Any questions for Darrell? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 129.
Good evening. My name is John Bowman, President of St. Louis County NAACP, here to testify in support of Senator Washington's Senate Bill 446, because we believe that anyone who has been found guilty and received the deprivation of a free lifestyle as they deserve should be treated fairly after they have found innocent. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 129.
Senators, my name is James Robinette again. Junior, I'm with the Missouri Conference of the NAACP. I think you all see our office right across the street next to Harris Pizza. Again, I'll read from my statement. We support restitution as stated in Senate Bill 446 in order to compensate a wrongfully convicted person for the time that was taken from their life and from their life in society and their family. Compensation will also enable them to transition back to society in a positive and constructive way. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 129. Further witnesses in support. Seeing none, any witnesses in opposition to Senate Bill 446? Oh, we have another witness in support. Okay.
Right. Sorry about that. I'll be brief. My name is Kurt Wickmer. I represent the Missouri Catholic Conference. To put it simply, we support this bill because the state bears responsibility for those convicted who are innocent, and therefore they bear the responsibility of paying back restitution to that defendant regardless of how their name is cleared. Thank you.
Any questions for this witness? Seeing none, thank you for your testimony. Any witnesses in opposition to Senate Bill 446? Witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, that concludes the hearing on Senate Bill 446. Next up, Senate Bill 128, Senator Thompson Rehder, whenever you are ready.
Thank you, Mr. Chairman and members of the committee. I am Senator Holly Thompson Rehder from Southeast Missouri. Under current law, a court may order a party in a divorce proceeding to pay a reasonable amount of court costs and attorney fees to the other party. What this bill, Senate Bill 128, would do is require in a court action, if a court has to enforce an order that has already been given by a judge in a divorce proceeding, then the person who is being brought back to court has to pay the fees and the court costs. And so what has happened to me, and then I found out that this is actually a very normal situation because family courts are so overloaded, is that when the judge gives the divorce order, finalizes the proceeding, gives the requirements of the parties, if one party decides they're just not going to do it, and they can take their time to do whatever, whether it's signing paperwork, signing a house over, or giving the split of the finances, any of that, if they decide that they'll just do it when they want to, the other party has to pay an attorney to file the paperwork, to go back to court, to wait in line again on that court docket for the judge to say, yes, I've already ordered you to do this, now you have to do it. And this has become quite common for those in domestic violence situations because it is one last hold that the abuser has on the person seeking the divorce. And so that is why with this bill, it puts some teeth into that order by saying if you don't do what the judge has already ordered you to do by the time frame that the judge is telling you to do it, then you will have to pay the other party's court expenses and attorney fees to bring you back into court to have you forced to do what you've already been told to do. It's a simple bill. Mr. Chairman?
Thank you, Senator Thompson Rehder. Any questions for the bill sponsor? Seeing none, thank you for your testimony. Witnesses in support of Senate Bill 128.
Hello again. I'm still Jeff Miller with Americans for Equal Shared Parenting, and we'd like to go on record in support of this bill. Anything to strengthen the use of the shall, anything to strengthen payment of attorney's fees by a non-compliant parent is helpful, and this is the key, to curb such future abuse by that non-compliant parent. It won't have a chilling effect because it's so rampantly abused right now. And here's the problem. The problem is I've done nothing wrong. I'll give you a real-world situation. Client goes to pick up kiddo, can't make it, has a babysitter pick up to do the transportation. The other side says, nope, you've got to be here personally to pick up the child. So we've got a dispute. With the time it takes to find an attorney, pay that attorney, get a court date, you may be 3 or 4 months without seeing your kiddo. So this type of change would be the most welcome, and we support the bill. I'd welcome any questions if the panel has any.
Any questions for the witness? Seeing none, thank you for your testimony, and don't forget a second witness form. Further witnesses in support of Senate Bill 128.
Chairman, Senators, I also support this bill. Kenneth Rosa from previously. I also support this bill because what happened over the course of the 7 years is I spent about $250,000 having to litigate and go back and forth in and out of court, even though I had a custody order for my children every other weekend. You can't get any of the agencies to enforce it, and the judges just say, well, don't do that and don't do that, and I was the one that ended up footing the bill for that entire thing, as well as being kept away from my son with a court order for over 3 years. So obviously I support this bill because no father should have to spend $250,000 litigating back and forth in and out of court just to see their child off of a parental plan that nobody's following. So I appreciate this legislation as well. Thank you.
Great. Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 128.
Good afternoon. My name is Jeremy Roberts. I'm from St. Charles County as well. Just to briefly piggyback on that, let's see, approximately when my daughter was around 3, we got divorced, and the end result was in and out of courts for someone that continuously violated the order. I had to file continuous family access motions. Those are roughly about $150 a piece. Then, as of right now, there's no deterrent for someone to follow it, follow what the order says, because that is our sole mechanism for doing so, and that when there is a violation is filing that family access motion to get that time back. But it is at an ongoing expense. Also, with the modifications, I had to do follow up and do another modification based on what had occurred with a parent moving once I moved into the school district, so our daughter could see both of us and have more frequent ability to spend time with both of us. She picked up and moved. The problem is the courts are very slow. The courts drug everything out. A GAL was assigned. That was more expense. The point is the courts seem to deter people from using their system by financially draining them, forcing them to settle. When what this bill would do is it puts the other parties on notice that if you're going to do this, you're jeopardizing your own financial stability. So the control that you may have temporarily needs to have some kind of recourse, and I believe 100% that this bill would help that deterrent. Thank you.
Thank you for your testimony. Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 128. Any further witnesses in support? Seeing none, any witnesses in opposition to Senate Bill 128? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 128. Next up is Senate Bill 367, which is my bill, and I'm going to turn the hearing over to Senator Schroer.
We are on Senate Bill 367. Senator, once you are ready, begin.
Thank you, Mr. Chairman. Members of the committee, for the record, Tony Luetkemeyer, representing the 34th Senatorial District, here today to present on Senate Bill 367. Senate Bill 367 protects businesses against the solicitation of employees and customers of a business by a former owner of the business. The bill does not govern the conduct of employees of the business. Senate Bill 367 protects only against the solicitation of employees and customers in a business. It does not deal with non-compete provisions, and it does not prohibit anyone from working for a competing business. Senate Bill 367 codifies existing Missouri case law with respect to non-solicitation covenants and extends them for a period of 2 years after the end of the former owner's relationship with the company. Senate Bill 367 provides all parties to contracts containing such covenants certainty as to the validity and enforceability of those essential covenants. Non-solicitation covenants contained in ownership agreements are essential to the success of any business in a competitive marketplace. Providing legislative certainty when non-solicitation agreements will be deemed enforceable reassures business owners that their investment will not be undermined by former business owners who sell their ownership in the business. And with that, Mr. Chairman, I'd be happy to answer any questions.
Any questions? Seeing none. First witness in favor of Senate Bill 367, please come forward, have a witness form, and begin when ready.
Mr. Chairman and members of the committee, for the record, my name is Brian O'Grady, and this is my colleague Scott Behrens. And we are here today providing testimony in support of Senate Bill number 367 on behalf of Brattin Companies, who supports this bill because it is a pro-business bill for Missouri. It provides a presumption of enforceability for restrictive covenant provisions only in regard to the sale of business. So former business owners soliciting employees or other owners of their former business or soliciting their customer accounts that they primarily dealt with after selling their share in the business. I wanted to reiterate Senator Luetkemeier's point that this is not a non-compete. This is a non-solicitation and only as it relates to the sale of a business. So these are sophisticated, negotiated arm's length transactions, and this does not affect or restrict any former employees of a business from soliciting any other employees or customer accounts. This is solely in regard to sale business, and if a provision is overly broad, this bill allows the courts to modify it so that it fits within the scope of the bill. And that's all I have. I'm open to any questions.
Any questions for the witness? Seeing none, thank you for your testimony. And if both of you could leave a witness form, it'd be greatly appreciated. Further witnesses in support of Senate Bill 367.
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition, want to go on record in support of this bill. Happy to answer any questions.
Great. Any questions for this witness? Seeing none, thank you for your
Thank you.
testimony. Further witnesses in support of Senate Bill 367.
Mr. Chair, members of the committee, Heidi Geist-Bueller-Sutherland here on behalf of the Missouri Chamber of Commerce and Industry. Like the previous witness stated, this is not about non-competes. I know those conversations can get a little bit touchy. This is purely to protect businesses and the customer base and workforce that they cultivate over a series of years.
Any questions for Heidi? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 367. Seeing none, any witnesses in opposition to Senate Bill 367? Seeing none, any witnesses for informational purposes only?
Mr. Chairman, Senators, I'm David Claridge, today appearing on behalf of the Missouri Association of Trial Attorneys for information purposes on Senate Bill 367. For the last couple of years, Mr. Chairman, as you know, we'd like to thank you in particular for working with us on these issues, trying to make sure that this language is not only upheld by the courts, but narrowly tailored to accomplish its objectives. And I'd like to thank Mr. Grote and Ms. Henderson. They told me that I had to do that publicly. So I'd just like to go on record for that purpose, saying that we'd like to thank you all for making this a product that we can not oppose.
Any questions for David? Seeing none. David, I've got another bill I'd like to talk to you about, too, that we can hopefully get a negotiated position on.
I'm not far.
Okay. No further testimony on Senate Bill 367. That will conclude the hearing. No further business coming before the committee. I'd make a motion that we adjourn. Do I have a second? It's been moved and seconded. All those in favor, signify by saying aye. Aye. Those opposed, no. We are adjourned.